Please join me in welcoming Professor Keith Weisburd, who is a professor of law at DC Law San Francisco. Very excited that you're able to give us this talk. Thank you so much.
Yes. Hi, everyone. It's so nice to see you all. Thank you so much for joining us today. I know there's a lot going on in the law school, so it's so wonderful to see you all. And please, this project is early in its creation, so I'm eager for your feedback and your thoughts. So let me just explain a little bit about what inspired this project. So before I started teaching doctrinal classes, I ran a law school clinic where we represented young people charged in delinquency court. And over, my law students and I, and so those of you who are in, just out of curiosity, are any of you in a clinic right now? Oh, awesome. Okay, so for those of you who are in clinic, especially if you've done criminal clinics or been in criminal courtrooms, this should sound familiar to you. It is very frustrating for my students and I because our young teenage clients who are on pretrial release or probation were routinely reincarcerated for technical rule violations. So not new criminal offenses, but violations that were detected only by machine, be it a GPS ankle monitor, a failed drug test, or prohibited material found on their cell phones. Because people on pretrial release, probation, and parole have few rights, and because, frankly, we didn't know how this technology worked, we often felt hamstrung in our ability to challenge these violations that our clients faced. And here's sort of a visual depiction of what happened. Our clients would be released on an ankle monitor, there would be a violation, they would be reincarcerated, and then released again. And from our vantage point in the clinic, it seemed like these various surveillance tools offered courts near perfect proof of inevitable imperfections with technical rules. And this experience is hardly unique. And I bet it resonates as true for those of you who spent time in a criminal courtroom. While the now ubiquitous use of surveillance technology in police investigations and trials continues to vex advocates and scholars, less attention has been paid to the increased reliance on sophisticated technology in the revocation setting in particular, even though half of all prison admissions stem from violations. So my project looks at how does surveillance technology sanitize and incentivize the near perfect automation of reincarceration. And while surveillance and revocation has been studied in isolation, this project hypothesizes that when operating together, they create kind of a perfect storm of highly mechanized definition, detection, proof, and adjudication of violations, a type of automated adjudication and reincarceration unprecedented in the legal system. And as part of this project, I make the case that people on community supervision are the miner's canary for automated adjudications that are both more technically advanced and less constrained. Their experience reveals how there's a pathological relationship between sophisticated surveillance technology on the one hand and the absence of rights and protections on the other, and together they create a sort of legal backdoor to incarceration. And what this means is that government officials can leverage increasingly sophisticated technology, numerous and easy to measure rules, and limited legal rights to more easily detain and incarcerate people. This inquiry is especially timely because technologically enhanced backdoors to reincarceration exists well beyond the criminal legal system. So many states are now experimenting with surveillance technology in prisons and jails, and we're also seeing an explosion in the use of electronic ankle monitors in the immigration context as well. And in all of these settings, the government relies on surveillance technologies to incarcerate, to detain, and punish people without the need to comply with the rules or scrutiny that typically accompanies traditional criminal investigations and prosecutions. So in this way, the automation of reincarceration exposes the full spectrum of technological power relied on to incarcerate marginalized groups overrepresented in many of these settings. So over the next few minutes, I want to do a few things. First, I'll just describe the ways in which technology operates in the community supervision context. I'll then talk about the unique features that facilitate this unprecedented automation, and then I'll talk about implications. So let me start with just talking about the technology itself. So there's several of us who have studied court supervision, including Professor Doherty. Is anyone here in her clinic? Awesome. Okay, great. So she's very much influenced my research. And she and I have thought a lot about the rules and lack of procedural protections for people on court supervision. But I wanted to specifically look at the role of technology in court supervision. And so to do this, a team of RAs, including Nat, who's here, helped me research the different types of technology across all 50 states. We looked at the 50 most populous counties and all 50 departments of corrections. And we specifically looked at 4 technologies. We looked at GPS ankle monitoring. We looked at applications and tools used to search and surveil cell phones. We looked at wearable devices that measure blood alcohol level, and we looked at drug tests. And I'm only now beginning to go through the amazing research that the students did and analyzing the results, but I'll share some of the preliminary findings. So the first is that almost every jurisdiction uses all of these tools at different stages of the criminal process, whether it's pretrial, probation, or parole. Many states don't collect data, so we don't have a ton of information, but we do a little, and I'll share with you what I found. So first, with respect to ankle monitors, some of you who've represented people in court or have just been in court may have seen these before. These use GPS to track people's location. They usually have a two-way microphone that can both listen and also state officials can speak through the microphone. They often have buzzes and lights and other features to alert. It alerts both the wearer, but also, of course, the people who are around them. We know that these are used extensively. And here are just a few snapshots so you get a sense. This is the number of people on GPS, either on probation or parole, in a few states that actually are jurisdictions that did give me data. So you can see that we're talking about thousands and thousands of people who are subject to this technology. And it's not just the technology. We also looked at the rules that people have to comply with when they're on this technology. So, for example, here in Connecticut, these are the rules that people who are on parole have to follow. Now, I don't expect you to be able to see in detail these rules. That's not the point. I wanted you just to see how numerous they are, how many there are. What you see on the left there is the rules governing just people on parole. Those are just the generic rules. And then on the right are the rules related to wearing a GPS monitor. And these rules are very detailed. So again, here are the rules for people on probation in Connecticut and GPS, who are also on GPS. And you can see some of the rules here, like really detailed rules about when to charge the device, how long to charge the device, that you can't be asleep when you're charging the device. I don't know how that gets enforced. But you can just see the level of detail that these rules require. Also note the role of private industry. So it is private companies that often write these rules and enforce these rules. And often will be who is sort of communicating directly with courts and judges and prosecutors. And it is indeed these private companies that will write when there are violations that then would trigger potential revocation. We also looked at alcohol monitoring devices. These devices are also used really extensively, and they do more than just measure alcohol. They measure just the presence. So it doesn't measure the amount. It's just sort of an up-down, whether there's alcohol present in usually it's someone's sweat or breath, but it also has facial recognition technology and GPS tracking technology as well. And then we also looked at drug testing, which is also very, very common. And I just put up the stats from Connecticut and Minneapolis just to give you a sense. We see huge numbers of people subject to drug tests and a huge positive result, or huge result of people testing positive. These are usually urine tests or now patches. So doing this sort of not really empirical, but somewhat empirical study, it was very hard to do this study because this was very revealing, I think. Many states don't track anything. We know so little about this technology. And as a researcher, that's so frustrating. This lack of information is really frustrating. And it stems from the fact that private companies, these are, a lot of this data is held by private companies that rely on trade secrets and other principles to not share information about how the technology works, but also just because it's really hard to count. It's much harder to count the number of people subject to an ankle monitor than it is, say, the number of people in prison or jail. But I think also what's happening here is that this lack of information is explained by a reality that is present in a lot of the research I do, which is that because these technologies are generally perceived as better alternatives than incarceration, and they often are, they escape every type of scrutiny. It's as if they get a free pass from any meaningful inquiry into their effectiveness or legality. So now let me shift and describe the 5 unique characteristics that facilitate and incentivize automated reincarceration and how this type of technology sort of contributes to reincarceration. And I think it's really helpful to compare sort of what happens in a typical investigation and prosecution. And for those of you who are in crim pro or have taken crim law, this should sound really familiar, sort of what's on the left, compared to what happens in the context of a revocation proceeding. So first, unlike technology used in a typical criminal investigation, surveillance technology in the context of modern community supervision targets specific people and specific places. This type of surveillance would be unconstitutional if used on the general public, but because people convicted of crimes have a lowered expectation of privacy and other diminished rights, including because they have, in theory, consented to the use of this technology, they don't enjoy the same protections that the general public might when it comes to this level of person-specific surveillance. And recall, too, that the conditions these tools enforce are themselves highly technical, meaning they're really easy to measure compliance with technology. So again, here we see these rules. There's so many of them. It is very common for us to see rules involving curfews, stay-away orders, house arrest, prohibitions on consuming drugs and alcohol, travel restrictions. These are all really common conditions of pretrial release, probation, and parole. And the technology makes it especially easy to detect violations of these super easy to measure rules. So practically speaking, think about it, police cannot, at least legally, randomly stop any person on the street and just perform a drug test on them, nor can a prosecutor access someone's geolocation data without a warrant. Likewise, there's no way, at least not yet, to detect and prove every single time someone, say, shoplifts or has a DUI, right? Like that just doesn't happen yet in modern policing. But such detection is possible for people who are subject to court supervision, whether they're on an ankle monitor or subject to alcohol testing. The second, I think, unique feature is that while strict liability offenses are generally disfavored in criminal law, the same cannot be said of proving violations. As you learn in crim law, generally speaking, a prosecutor has to prove that a defendant had the required mens rea, had the guilty mind, and generally speaking, we disfavor strict liability. But technology makes it so easy to prove certain violations that violations become, in essence, strict liability offenses. Think of somebody facing revocation for a failed drug test. The government need only establish that the test was failed, and that then triggers liability. No evidence of a mental state in that type of violation is required. Third, unlike technology relied in the context of criminal investigations and prosecutions, technology in the revocation setting is subject to significantly less scrutiny. People facing revocation are not afforded the same trial rights as people facing criminal charges. People on court supervision have limited Fourth, Fifth, and Sixth Amendment rights, and they often waive basic constitutional rights as a condition of being subject to this type of technology. Now, to be sure, and I know that many of you might share the skepticism, individual rights and trial safeguards against unreliable policing technologies are often incomplete and ineffective, but trials at least offer some minimal procedural checks against automatic convictions based on flawed technology, such as the Frye-Daubert requirements, the right to confrontation and counsel, a robust standard of proof beyond a reasonable doubt in trials versus in the revocation setting, it's just a preponderance of the evidence, the right to have the jury make an ultimate decision on guilt regardless of the strength of the evidence. That's all true in the context of a trial and a criminal prosecution, but not in the context of a revocation hearing. Fourth, as compared to investigations and prosecutions, revocation proceedings have even less transparency and public accountability. As I mentioned before, private companies retain the data and share little about how the technology operates. In fact, I was just talking to the Philadelphia City Council about the use of GPS technology, and the council members were so frustrated that they didn't know what was going on with the data. And they kept saying, like, well, where is the data? Who has the data? Who's it shared with? And none of us could give them any answer because it's the private companies that hold this data. Revocation hearings are not in the public eye, and we have little data or insight about how this technology is used. We have so much more data. We have a lot of data in the criminal justice system. We have a lot of data on arrest rates, on stop rates, on who gets stopped, on who gets charged, and on what sentences people are subject to. This type of data just doesn't exist in the context of community supervision. Finally, there's this question of discretion. Discretion plays a distinctive and surprising role when it comes to technology used in community supervision. So a lot has been written about the abuse of discretion in the criminal justice system and in the supervision context in particular. I certainly emphasize that in teaching 1L crim law, just the immense role of discretion that prosecutors and judges have. But surprisingly, there's actually less discretion in this setting than you might expect. Sometimes the lack of discretion is baked into the rules themselves. People agree to be incarcerated, basically, or arrested if they violate any of these rules. And you can see examples of that. Also, we are seeing more and more laws getting passed mandating the use of electronic monitors, for example. So some states are passing laws that require electronic monitoring for certain types of offenses. Other states have passed laws requiring a mandatory sentence or a mandatory arrest if there's a violation. In California, for example, this isn't a new law, but in California, people subject to lifetime electronic monitoring, of which there's 10,000 people on GPS in California on lifetime GPS monitoring, tampering with the device, which includes letting the battery die, triggers an automatic 180-day mandatory prison sentence. And there's no discretion. There's no way for a judge to not impose that. So this lack of discretion is not just related to GPS ankle monitoring. At the federal level, supervised release violations involving drugs trigger a mandatory 5-year prison sentence. So a failed drug test in federal court can mean a mandatory sentence. So what does this all add up to? So in a typical criminal investigation, there are these points of friction. There's these things that sort of slow down the automation. That doesn't make it super automatic. There's sort of these points of checks, of safeguards. And the same is not true in the context of community supervision. Those safeguards are gone. The friction is gone. And so we do see, we talk about trial by machine, but at least in the context of a typical criminal prosecution, that yet hasn't totally happened, but I would say it has happened more so in the context of community supervision. These points of friction just don't exist in the context of revocation. And indeed, the Supreme Court's most recent case on supervised release, which was United States versus Hammond from a few years back, it raised but did not resolve this exact problem. And many case commentators have talked about this case with respect to like sort of how much process is due to people who are on community supervision, and that is really ultimately what the case was about. But what's missing, or what's really interesting about the case when I sort of reread the lower court's decisions and the transcript, is that really the district court and the 10th Circuit were deeply concerned by the government's reliance on questionable technology in that case. In that case, it was a cell phone search. And the district court was really worried about the fact that this evidence was coming in at a revocation hearing where the burden of proof was lower, and that the judge felt like he didn't understand the technology and was basically being and it triggered an automatic 5-year mandatory prison sentence. And the district court was so troubled that he reprimanded the government multiple times for not helping him understand the technology, and observed that, quote, "If this were a criminal trial and the court were the jury, the United States would have lost." So he ended up finding for the government, like, over a lot of protest. And so I think that case sort of proves that this is a big problem, the reliance on technology in a setting outside of a criminal trial or investigation. So what are the implications? I think there are a few. So I want to highlight how these special circumstances operate together to incentivize a backdoor to incarceration. That is, incarceration resulting from the government sidestepping typical system checks and procedures. And the implications are important for the 4 million people on court supervision in the United States, but also as a harbinger of what this sort of incarceration by machine might look like in other areas. And I really would love your thoughts and feedback on these implications, including implications I may not have thought of. So as an initial matter, there are strong system incentives for both courts and prosecutors to increasingly rely on technology to justify revocation and reincarceration. In the revocation setting, the burden of proof is lower, and there are fewer procedural safeguards as compared to trials. This means that a prosecutor will almost always elect to charge even new criminal allegations as a violation if they can, because it's so much easier to get someone incarcerated that way than through a typical criminal trial. Judges have similar incentives. For example, the perceived ability to measure whether someone has complied with a stay-away order or to stay 1,000 feet away from a particular location kind of encourages the use of technology, because think of how it makes the judge's job so much easier, because they can sort of quickly measure whether someone's complying or not. Another consequence relates to the incentive for private industry innovation. And this incentive really stems from two realities. First, the demand for community supervision tools is dramatically increasing. This is especially happening today as we see a sort of retrenchment on bail reform. So as bail reform loses favor and we see the pendulum swinging back to imposing bail and relying on cash bail, we're seeing a real explosion in the use of electronic monitors, often by bail bondsmen, so it's not always even the court imposing the electronic monitor. But also, because these revocation proceedings operate in this kind of legal gray zone of rights, and there's really no regulation or oversight, private companies need not worry about lawful or unlawful surveillance. Instead, they can innovate with these populations. They can use people on community supervision, or for that matter, people in immigration proceedings as well, or in prison, to experiment with new forms of hyper-invasive, person-specific surveillance. Surveillance, again, that would be clearly unconstitutional if applied to the general public. I should say, too, at the same time, recent legislative and regulatory efforts aimed at protecting digital privacy have specific carve-outs that exclude individuals in the criminal justice system. And a colleague and I recently wrote about how, for example, consumer data protection laws often have specific carve-outs for people who are suspected or convicted of crimes. And case law, too, offers little in terms of protecting people on court supervision. Lower courts have almost uniformly interpreted sort of the data rights protecting cases like Carpenter, or even evidentiary cases like Daubert as only applying to police investigations or to the trial setting, and as not applicable to people on community supervision. So when examined together, we see this sort of pathological relationship between the sophistication of the technology and the lack of rights as a way for the government's increased ability to incarcerate people without having to abide by the traditional rules of criminal trials and adjudications. So I could go on, but I actually really want to hear what you all think about this. This is a new idea, so I'm going to stop there, and I welcome your thoughts. Thank you all. Can I just take questions? Yes, please.
So this was really interesting overall, and it made me think like a lot about the uncertainty that's within all these technologies, whether there's like faults in them. I've looked at like facial recognition some, so it's not perfectly applicable here, but it's similar.
Yeah.
And within each of these technologies, the developers always understand that there's an uncertainty. When they're writing the code, they'll have some sort of way to account for that. So in facial recognition, there's like some sense of certainty, and you can put a threshold to prevent false positives.
Yeah.
I wonder to what extent like that comes up in this technology. Is there oversight over how they set those thresholds? Like in GPS, I imagine you can say you have to be 5 feet beyond the boundary for us to actually make a call. And so in some sense, it seems like these companies are choosing an additional burden of proof themselves without any government oversight.
Yeah, no, that's a really interesting point. I think that's right. No, there isn't oversight. I mean, that's what's hard, is there's no regulation. I mean, these are companies, and it's interesting because actually bail bondsmen are now just opening up their own like sort of garage GPS shops, you know, like this isn't even government agencies. It's just the sort of like the bail bondsman has just replaced, you know, some sort of collateral with like putting people on an ankle monitor. And there's really no oversight, none. So it is on the companies to sort of decide. The thing about reliability that I think is interesting, I'm curious if this resonates with you, is like, there's no question that this technology is not always reliable. But I also feel like reliability is a little bit of a red herring. Like soon it will be, you know, like I don't know how soon. But at some point, I don't know if the reliability arguments are going to win the day in court. Like we're going to get to a point where this is very, very reliable. And sure, there'll be cases where it's not. But I think the hard question is, what happens when this technology doesn't have a reliability problem? And I think that's kind of what's interesting about this project, is it's kind of almost assuming, not assuming that it's reliable, but sort of thinking ahead to like, what does the world look like when we really do have reliable proof? Yeah.
There's something like inherently more unfair or immoral about being monitored by a computer than a person.
So interesting. You know, I don't know. I mean, I myself haven't been subject to either, but I think that when I was in practice, it always felt as though the human interactions were way more valuable for our clients. I mean, it's like much more valuable to have a mentor than a machine. And the machines often, like the ankle monitor, often undermine, certainly in juvenile court, the rehabilitative goals of juvenile court in a way that, say, a very involved mentor or probation officer who's actually having contact with the young person is much more effective. But certainly I had plenty of clients who wanted to be on a monitor. I mean, this is the hard thing about practice, right? Is that, and this is why getting to write about this feels like such a privilege, because when I was a lawyer, I represented my client's stated interest. And oftentimes they would say, please ask for me to be on a monitor because that's the only way I'm gonna get out of custody. And they're right. Like I knew that the judge wasn't gonna allow them to get out. So I don't even know if it was that they preferred a machine versus a person. It was much more pragmatic. It was just, that was the only exit from incarceration for them. But it's a good question. I mean, do you have a thought?
I don't know. I struggle with it. I mean, even if like these things are better in some ways, that I mean, sometimes you get a crappy PO, or you know,
Right.
But something about it feels intuitively worse, and I just don't know why.
Yeah.
Because it's not just about error rates, because sometimes they're better than human beings.
Yeah. Yeah. I think we have to assume that at some point. Yeah.
I could respond to that. I think my instinct is that it's worse because of the totalizing nature of it. You're like parole officer is gonna be following you around every single day and like monitoring things like, oh, I like fell asleep on the couch and I let GPS thing die and now I'm getting like, you know, they're not monitoring your habits to that extent. So I think it's worse in the sense that the technology has the ability to monitor you round the clock in a way that a parole officer just doesn't have the physical omnipresence capability and like literally like cannot be awake for 24 hours a day, even if it was they were just dedicated to you to follow you around your house and to see exactly your habits, whereas this does.
I mean, it's sort of interesting though, because I think that it depends on what we're measuring too, and what the point of it is, right? Like if we're asking like, what would a young person or anyone prefer? Well, that's one thing. Like maybe you sort of prefer to not have somebody all around you all the time and would prefer, I don't know, it's hard, but if it's measuring sort of, is it the way that you get out of custody? Well, that's like gonna be a different answer, I think. I'd love to hear other thoughts, yeah.
So this kind of life monitoring technology is actually very widely used in China right now. And in a lot of local governments, they have the project that's called small city or small government project. They will have a centralized room and then they would life monitoring all sorts of like social aspects. And in this way, it makes it easier for the government to target the potential social problems.
Mm-hmm.
So I can see the advantage of the application of this kind of technology is the improvement of the governance effectiveness. But at the same time, there's an argument, right, a criticism from the Chinese scholars. They say it's kind of a violation of the presumption of the innocent, the principle of innocence.
Mm-hmm.
So I'm curious about how you understand, like, how should we choose between these kind of two interests?
Yeah, no, it's true. I mean, it would be hard for me to argue that we shouldn't have alcohol monitoring maybe in some circumstances. Like, and that's not my position here. It's just that we have to understand what the consequences are. And in terms of the innocence question, so and with respect to your first point, yeah, I think this technology does make things more efficient. If efficiency is like, this is the point the both two of you were raising, if efficiency is the goal, then sure, this technology is hyper efficient. And as to the innocence issue, I mean, so I've perhaps improperly sort of lumped everybody together here in terms of both people who are pretrial, so are presumed innocent, and people who've been convicted, and they are differently situated legally. So I do think that people pretrial have like obviously more robust rights than people who've been convicted. So certainly I think there are stronger arguments to be made for people who are pretrial, but I think the reason I've lumped people together, like sort of these three distinct areas, like pretrial, probation, and parole, is that the technology operates in the same across all of those stages. But there are certainly very good arguments to be made that for people who have not yet been convicted of crime, there are perhaps additional concerns that we'd have. But those same concerns exist for people on probation and parole too. Yeah. Other thoughts, questions? Yes.
So this ties into, I think, a few of the points that have been made, but it seems to me like your argument has a really tough normative path that it has to carve out, because you are arguing for a decrease in the congruence between the rule and its enforcement. Whereas usually that's one of the basic principles of legality, of due process, of fair notice, is that enforcement of the rule should adhere as closely as possible to the rule. But you're arguing that because we're automating this and eliminating the friction that usually exists that keeps all violations of a rule from being prosecuted, those are going away. So we are in fact having more congruence. But I think you're arguing that it's too much congruence. And so this gets into the points of totalizing, but I think making these, the problem is that it's totalizing arguments are hard because of that. It's a fundamental part of the rule of law. And so why does your argument not collapse into, we simply have too many, like the challenge to the underlying rules, not the use of technology. So we just overpromise and we make it far too easy. And
Yeah.
I think maybe a way you could carve that out is to distinguish between two kinds of rules that would trigger reincarceration. One kind are things like alcohol monitoring, being in places that are, have alcohol, things where you understand a distinct like normative basis for why we would want someone who has been put out on parole to be in that place. Versus the like rules that are coming about just because of the technology itself. So like you need to be in a place for 2 hours to charge it consistently at the same time of day, every day. That has no external
Yeah.
normative grounding other than the fact that the like tech company wants you to use its product. And maybe that's a way, and you can have a way easier time making an argument for why the use of technology is kind of invalid when applied to like those technology specific rules versus rules that are normatively grounded on why we like monitor people on parole in the first place.
Right. No, I think that's a really, it's something I struggle with a lot in a lot of the papers I write, as you can imagine, because at the end of the day, I mean, to really resolve this problem is just would be shrinking the front door, like the number of people coming in. And so to some extent, but I feel like I can't say that in like 8 different papers over and over again. But I think you're right. And I think I have to think through more like the prescription part of this project, which I haven't fully, like more procedural rights is not necessarily going to take us to, that's not necessarily the right, I mean, like, it's not as if more procedural or more transparency, like that seems necessary, but not sufficient. And so limiting sort of the basis for revocation is something I have to just think more about. But you're right, like it does feel like there's a difference in some of these rules, like the hyper technical rules that have to do with the technology. I mean, but in California, like I was just talking to a public defender the other day who had a client who was unhoused. He didn't have regular access to electricity. His monitor went dead. And like an hour after it went dead, he went to the San Francisco airport and charged it. And he faced 180 days, mandatory sentence for that. And I think that's your point, right? Like, I mean, what are we doing? What's the normative value in putting him? And I think so many people just go through that cycle that they've sort of become used to it. That's not even something that they necessarily want to fight. So it's interesting. Yeah.
I don't know if this is responsive to that point. So there is, I think, a first order principle that we've assumed in a democracy where we want to protect liberty, that we will create friction en route to depriving liberty. So for example, a guilty person will be presumed innocent and they're not to cooperate or help in the achievement of that conviction and may even go free and be acquitted. And we as a society have said we would prefer that error, if you will, than the error of efficiency in the deprivation of liberty because of the consequences that the deprivation of liberty produces. So I think a way of looking at this is kind of like, what is the presumption that we're starting from? And I'm even thinking of Scalia, for example, in his opinion regarding GPS. He says this is a violation of the Fourth Amendment because it is so totalizing. And there isn't the frictions that require, let's say, a police department, for example, to start making decisions about who they want to investigate, how much agents they will put somewhere, and it allow for the prioritizing of resources in such a way that it doesn't allow for a totalizing, like, surveillance state, if you will. And I think what's being said there is that the assumption is we all break the law. The question is, when should it be investigated? If investigated, when should it be prosecuted? And then if prosecuted and convicted, when should it include incarceration and so on? So the assumption is that we're all breaking the law, but not everyone should be all over and over criminalized for it. Now, that leads me to my question here, because I see a lot of the capitalist structure here with obviously the incentives of the private industry. And I'm sure class will come to play in this analysis. But there's a racialized capitalism problem where there's winners and lots of losers, but the losers are not distributed equally. And the winners are not distributed equally. And so they tend to fall on the poor and the marginalized community, particularly in the US, Black folks and brown folks. And so that part of the question, I don't see necessarily like explored here. And I will just say about the question about moral oversight of a computer is not necessarily a preference. So preference is pragmatic. So I'm sure people in Jim Crow would prefer Jim Crow most, not people in convict leasing. to slavery,
Right.
right? But because it was preferred doesn't make it good. In fact, that was some of the arguments of the South,
Right.
right? That it was, look, they're not that disappointed, or they would say, well, they were happier before, whatever the case may be. Morally, the question is, does this surveillance of a computer produce the flourishing life, a socialization of democracy along the lines of, for example, Vesco Weaver? And I think those two things are different. And
Yeah.
if you create a situation where incarceration is the option, yeah, getting out is a thing. My sister, in Florida, we have hurricane storms. Her monitor went off, 3 years in prison because it wasn't charged
Right.
while there wasn't any electricity. She had already 2 infractions prior, so this one is the one she didn't really do. She just goes to prison
Yeah.
for 3 years. So I would like to see your thoughts on
Yeah.
the racialized capitalism and how it informs and instantiates this problem.
Absolutely. So there's a great article by Michelle Alexander called The New Jim Code, where she makes the argument that you just put forward, which is this false choice, this fiction of choice of like, electronic monitoring being better than prison is almost used, and I've made this argument in other papers, is almost used to sanitize it and to sort of justify sort of this like consent as fiction. This sort of, you've consented to it, therefore there's no problem. But of course that doesn't make any sense. That's like saying like someone consented to the firing squad instead of like a death by, lethal injection or something. I don't know, like that's like, those are not two, both are pretty horrible alternatives. And there's some great work by Chaz Arnett at University of Maryland. He wrote a great paper called Data is the New Cotton, where he basically makes the case that the technology like this is basically trafficking in the data of marginalized people and capitalizing on sort of selling it and using it. So that will definitely be part of this project. Yeah, thank you. Yes.
I'm curious. It seems like contract law might be more useful to challenge some of this than criminal or constitutional law. Like specifically the idea of express conditions that cut more to evidence than substance. In like a contracts context, courts can choose not to enforce the contract if it's not actually about the underlying substance or the purpose of the contract.
Yeah.
That seems to be in play here when we're talking about charging, talking about all of these things that they're not laws. These are just express conditions of the contract that cut nothing to guilt or actual violation.
Yeah. Think about plea bargaining. That's a contract, and courts are fine with that. Like people have made contract arguments to invalidate pleas, and like Bordenkercher versus Hayes, which you may have read in Grimpro, the court is like, we are fine with that level of negotiation. That is just the give and take. And so contract arguments, I mean, I am no contracts expert, but they don't go very far because consent is relied on so much. This idea that like it was informed, you saw the rules, you agreed to them, maybe as part of a plea negotiation, which these tools are often imposed as part of a plea negotiation. And there's just the case law is, I mean, it's pretty stark. It's very clear. Like it's very rare that a plea bargain is invalidated. And so it's hard to imagine that this would, if plea bargains aren't invalidated, that this would be invalidated. But you're right. I mean, I do think there's really good, it's like contract of adhesion issues, right? Where like, it's not as if the defendant can like bargain over the terms. I mean, if they want to bargain, what the private company or the court would say is, well, your other option is prison. But that doesn't seem like a fair contract either. So you're exactly right to question this from a contracts perspective. I just don't have a lot of optimism that contract law is going to take us there. Yes.
Yeah, I'm curious if you've seen any difference or deviation between rules between the like different versions of the same technology. So like if we use this framework of like technical and non-technical rules, my expectation would be that like as the company develops newer, more resilient models of an ankle monitor, for example, there should be fewer technical rules because it would have like a better battery life,
Yeah.
be more resilient to not being charged under certain conditions. And then the non-technical rules should become a lot more specific because they're able to measure, for example, not just binary of whether you drank alcohol, but like the specific degree to which you consumed it. So have you noticed any of that like between different models of the same?
Not yet, but I think we will. I think that's exactly what we're going to see is we're going to see, like, for example, one thing that's already changed is the technology has now shifted from an ankle monitor to something that looks like a Fitbit watch. So in a way, that's, I don't know, less stigmatizing, sort of less like the sort of scarlet letter, if you will. But it masks all the remaining problems. So it's not really a great solution. The other thing too that I think is difficult is that these surveillance technologies, as you're suggesting, there's the rules that have to do with the technology that could disappear. But then because the technology is so good at measuring the other violations, like violating a curfew or leaving the state or something like that, that we would see an uptick, I think, in those violations. So sort of even if we got rid of the sort of violations related to the technology would still facilitate a sort of ever expanding net, if you will, of being able to measure other types of violations. So I think that's the right thing to be thinking about for sure. Yes.
Hi, thanks. So yeah, I guess I have two questions. So one is just more like a clarificatory question. I'm surprised you mentioned that sometimes you can be subject to essentially a strict liability.
I'll put that back up here.
So I think I would distinguish between cases where you've been convicted and sentenced, and then you're released on with ankle monitoring, and then that release is revoked because of non-compliance as detected by the technology. But it seems like you were saying that there's a somewhat different and significantly different scenario where, let's say, if you tamper with your ankle monitor, it seems like you're actually being convicted of a separate offense, and because right in the first model, like your overall sentence doesn't increase, right? But in the second one, you actually might be subject to additional prison time. And then it seems there that the argument that, well, your rights are reduced because you've already been convicted, just doesn't apply, because it's just a completely different offense. So it just seems to me that there's something objectionable about having just no mens rea requirement for that kind of separate conviction, essentially.
Yeah, no, it's a good point. I mean, they're not treated as, I think what you're saying is they should be treated separate, but they're not treated separately unless it happens to trigger a new criminal charge. So in Washington, D.C., for example, the failure to keep your device charged is a misdemeanor. So people in D.C. are just prosecuted in a new case for not charging their device. And that, I do think there's probably more of a robust mens rea requirement. But in the setting of sort of revocation based only on the output of a machine, and it's not technically a new offense, it's just a violation. And there's the case law here, not surprisingly, is not great in the sense that it's not viewed as its own new offense. It really is viewed as sort of you had the privilege of being released, and that privilege is revoked if you don't comply with the rules.
Can your sentence be increased beyond what you?
It shouldn't be. Sometimes it shouldn't be. But still, a lot of people who are on probation still have 10 years to serve, then just get it. It almost makes no practical difference because they're still just going to face a pretty significant amount of time in jail. Yeah. But I appreciate that point. Yeah.
And sorry, I had a second.
Yeah, please.
So, I'm not a Fourth Amendment scholar. I'm a little bit more familiar with the First Amendment version of this. But so the code has held that people who are incarcerated they still have First Amendment rights. It's just that it's reduced. But the reduction is supposed to be justified by the context of incarceration.
Security needs.
Yeah, the needs of prison, security, and discipline. It seems unclear how that applies in this context, but also from what you've been describing, it seems it's not a case where your Fourth Amendment privacy rights have been reduced. It just seems to be gone. There's just no privacy. So I don't know what's the residual.
Oh, there's so much residual, so much. You're exactly right. It's so interesting because Carpenter is always heralded as this great case for privacy and for the Fourth Amendment. But basically, the justification that judges have given over and over and over again is that people who have been convicted of a crime, it's different if it's pretrial, but still, people convicted of a crime, which is the 4 million people that I'm talking about, have diminished rights. And then there's like a split on how that's viewed, whether it's no rights or diminished rights and why. And in some of the probation search cases, like, like one justice said something like, well, just because you've been sentenced, just because you've been convicted doesn't mean that all of your constitutional rights just disappear. And there has to be some basis. I mean, it's not analogous to prison where there is a security need. What is the need here? And the justification is usually some sort of rehabilitation, public safety, like all of these tools have government interests. And in other papers, I've made the argument that like the privacy interests sort of outweigh some of those government interests. But that has not gotten very far other than my law review articles. Yeah, but thank you. Yes, please.
So I'm not from this universe at all. Please forgive me if some of this is naive. I have a set of questions. One has to do with the budget allocations. So when funds are allocated towards these devices, are they being allocated away from the human beings that we were describing about? Has anyone done any studies? So I was very struck by what you said about human monitoring as mentorship. So has anyone studied the degree to which reoffending occurs when a human being is involved versus the monitors? Because I feel like that's a pretty powerful story. And the third is, I'm just curious about the background through which these monitors got analogized to regular parole, even though arguably they involve a degree of diminished liberty and trust. And so I wonder why they weren't used for a separate category of you're out and you're being monitored, but to a pretty intrusive degree, as opposed to parole, which has traditionally been like a level of trust that presumably you've earned. I don't know why it was either or as opposed to like completely different things.
Yeah, no, it's a great point. I mean, both of these questions are making me think I do need to make clear that there are different considerations for pretrial probation and parole. I mean, parole, the issue with parole is so interesting because like there are people who are on lifetime GPS monitoring. In California, it's 10,000 people who are on it for life. And at that point, you're right. I mean, I think what you're saying is like, is there the same justification in that setting as compared to say probation or pretrial release where in the setting of parole, there's a level of trust that doesn't exist in those other settings necessarily. So I think that's right. I don't have a good answer other than like, yes, I agree. And then as to the humans versus machine versus people, there hasn't been very much study. It's one of the things that's really frustrating to me is much of the empirical work and sort of research that's been done on electronic ankle monitoring has looked at ankle monitoring as compared to prison and which one is cheaper. And ankle monitoring is cheaper, according to those studies, and which one is more effective. And people are like, well, ankle monitoring is more effective because people aren't in prison. But I think that that's actually the wrong comparison. Like that just assumes two alternatives. It assumes incarceration or surveillance, but there's a third alternative, which is neither, right? And so I think it's really important that we do more research to examine exactly what you're talking about, to look at outcomes between people who are on monitors versus people who are actually getting support in the community, resources, all the things that allow for people to survive and thrive. But that research doesn't exist yet. So yet, maybe will at some point. Other thoughts? Yes, please.
You talk more about the interplay of bail reform and the use of surveillance technology. You talked about it in the context of the peel back of bail.
Yeah.
But I'm also thinking of in Chicago where they replaced it with a system where a judge to make a risk assessment. And oftentimes in my experience working with people who are facing rearrest, this actually led to like them where they would have gotten a cash bond. Now, because the history of technical violations for previous felonies are being detained pretrial. And I just think there's like some kind of tension between at this node where there's like some replacement of like an automatic system or automatic process.
Yeah.
Hearings with more discretion. Also, at the same time, there's been a rise since bail, like end of cash bail, and the increase of electronic monitoring.
Yeah, maybe that's the answer. It's just like going up in both contexts.
Yeah, so
yeah.
Those were like discretion attention and kind of working in reverse, but then also filtering back into each other. So I'm just wondering.
Yeah, no, and it's really interesting is in San Francisco, in California, there was bail reform, pretty notable bail reform. And this is the pattern in California and Illinois is the same actually, which is that bail reform, judges, because they couldn't use cash bail, were putting a lot of people on monitors. And so in California and in Illinois, we saw both like an increase in, with bail reform, we saw an increase in electronic monitoring, but not a decrease in the jail population, which is concerning because you'd sort of assume that there'd be an increase in electronic monitoring and a decrease in the jail population if it's being used as a replacement. But that wasn't happening. Like both populations were going up, the jail population and the monitoring population. But I just think something else, what was motivating it was judges not wanting to release people without some sort of insurance policy. And now I think that's just a different motivation. Now it's just like, well, we've been using it for so long and we're imposing cash bail and we still have this technology, so we may as well use it, which is, it's really interesting though, really interesting. Yes.
Hi, thank you for the presentation. I think this is one of those instances where the state and these convictions come together with very two powerful process. I'm curious, maybe if you've done research about it, or someone that's talking to like prosecutors and judges, what do they think about the limitations of these technologies? So I'm just curious about the lower level, prosecutors, especially the state and in the county. How are they thinking about this?
Yeah, I mean, I have talked to prosecutors and judges, and certainly from when I was in practice, I had a lot of interactions with prosecutors and judges about this. And I think that, and public defenders too, I mean, it's because it feels sometimes like and not just feels, it is the only way someone is getting out of custody. It almost feels like this necessary tool, but query whether that's actually true. Like to my prior point, I mean, there is a third alternative, which is just releasing someone with not an ankle monitor. But I think it's really attractive to judges, right? I mean, it's like basically ensuring it's like a insurance policy where if they're nervous about releasing someone, it offers them a really sort of more comfortable way in their minds of sort of in quote unquote keeping an eye on people. So I think it's very attractive. I mean, that's part of what I think makes this all so automated and frictionless, is because it's so attractive. It's almost like hard to resist because it's such a powerful tool in the tool belt of a judge or prosecutor and a public defender too. I'm not gonna, I think public defenders I've talked to have also sort of been skeptical of some of my points because they're kind of like, well, I agree with everything you're saying, but we really need this for our clients. Yeah, so it's really complicated. Yes.
On the point of monitoring being better than incarceration.
Yeah.
With the understanding that this is not your main project, but I'm very curious.
Yeah.
It seems to me like there's still an open question as to whether, even if we assume that those were the only two alternatives, whether surveillance is actually better. Because if you're looking at an individual person whose option is incarceration versus surveillance, obviously for that person, being released on surveillance is better.
Though there's been a study of people who've been on both, and they've said, I prefer prison. But part of the problem is then it ends. And it's also like, what are you comparing? It's like 1 year of incarceration versus like 5 years on an ankle monitor. Well, I think a lot of people might choose incarceration because then it is over faster.
Right. So the question, so if you're only looking at the group of people who's facing that release, there's one consideration. But then if you expand your view to the people who were going to get released anyways,
right,
and are now in a circumstance where they might face rearrest, where otherwise, previously there wouldn't have been that option. It seems like, are there any data? Is the group of people that are getting released who wouldn't otherwise actually bigger than the group of people who are getting reincarcerated who wouldn't have been without?
This is the $1 million question. And if any of you want to write like a dissertation or a note, let's talk, because I keep hoping that we will see this type of study. It's very hard to do the study. It's really, really hard because it's like, what are we comparing? And the pushback I always get is sort of like, well, if we didn't have ankle monitors, wouldn't all these people be in prison? But I don't think that's accurate. Like in a world without ankle monitors, certainly some people would be, but a lot of people wouldn't be. And to distinguish who would be incarcerated in a world without ankle monitors and who wouldn't, it's really hard because it gets up to like, what are we doing with these? What's the point of this technology? What are we actually accomplishing with it? And when you look at sort of the criteria, I mean, in some ways, like I think some of the laws that are cracking down on discretion are doing so because there isn't really any criteria of who goes onto a monitor and who doesn't. And so lawmakers, I mean, frankly, lawmakers should be part of my project too, in the sense that they have an incentive to use electronic monitoring as a way to remove discretion from judges and prosecutors and force certain groups of people to just be on a monitor by virtue of whatever charge it is. But we really need to do this study. There is great data in San Francisco, actually, that I'm hoping to work with the San Francisco public defenders on, which is that for about 6 months, there was a federal court order that basically stopped the use of electronic monitoring in San Francisco. So it's kind of this like natural experiment, like what happened in San Francisco during those 6 months when they didn't have electronic monitoring. My hypothesis is that people still showed up to court. Right? Like it just didn't change anything that much, which would be really useful to know. So stay tuned. Hopefully that we will use that data at some point. Yeah. Other questions? Yeah, I'll go back to any new, Nat? Yes.
I'm wondering, this is just lack of knowledge about how corporations work.
Yeah.
Sorry, everyone, but are there avenues to getting this data that's housed with companies, and would that be like a legislative effort?
Well, you know some of this from your research with me, but it's to some extent like, you know, Elizabeth Warren put out letters asking private companies to tell us stuff, and they didn't tell us very much. Subpoenas. So I'm working with a bunch of public defenders now. We're trying to come up with like a subpoena that will actually have the required like technical text, technical whatever. I'm not a technology expert, even though I think about it a lot, to request that through the subpoena power. And then discovery. So I kind of hope that like, you know, when there's motions to suppress, there can be discovery through that process of figuring out, and there certainly has been, and there have been examples of this where sort of the reliability of the technology is contested, and through that you can learn about what the private companies are doing, but it's really that's it, because they're not subject to Public Records Act requests, right? I mean, they're basically, you can't penetrate through like what they're actually doing, you just don't know. So it's really discovery, subpoenas, and that's it.
Which then those have to be attached. So
to law, to litigation. Yes, exactly. Yeah. So these are great comments. Anyone who hasn't asked a question yet, just I want to make sure, because I'd love to hear what you guys are thinking. Yes.
Conversation about contract theory.
Yeah.
You probably already have this, but Sadie Blanchard has a
Yes, I love that paper. Yes, I know that paper. Yes, I know it and love it. Thank you.
Yeah, so to answer a simple second one, I would prefer reincarceration to supervision. In fact, I was trying to negotiate 10 years probation into a year or two into incarceration. And that not a one-for-one, obviously.
Exactly.
So I just want to do a little bit of the analysis here, because there was a question about the budgets and how it's really from human.
Right, yeah.
So here's the crony capitalism, right? So most people on monitors have to pay a monthly fee, so you're subsidized. If you're most likely a low-income person, you're probably getting government support, right? So you might be getting SNAP, you might be getting other subsidies, and you're paying this electronic monitoring company to get this. So you're redistributing from a welfare to a private company, a form of redistribution. Now, let's say that person gets violated and sits in jail. Well, that's redistribution to the jail or the urban lake that provides an employment for both the officers, the nurses, etc. But if they get sent to a prison, most of them is a redistribution to the rural areas. And so here you start seeing how there becomes difficult for lawmakers, once it's created, to pull back the what's already being entrenched economically. When I worked in the Florida Capitol, when I was in undergrad, and I could tell you, all those private companies, including the retail lobby and many others, are there fighting to keep certain laws on the books that will criminalize and keep people incarcerated. The last thing I would just point out is on the question of sentencing, while many states might just give you the balance of your supervision, in Florida, you get up to the maximum that your charges carry. So in my case, I had 7 years of supervision. My charges carried up to 30 years. After the violation, I got 30 years. Thankfully, a case came out and get reduced to 15. The point being is that they're not bound to the 7 years I was on supervision. Because they withhold the imposition of sentence, which is a legal fiction, so that they could then give you a final sentence which won't violate the double jeopardy. One, but also when you ask, is this a new infraction? If it is, you can still get the violation as an infraction and the crime.
Right.
It isn't like you will only get the new infraction as a crime. So I just wanted to illustrate those things because this is not normally taught in law school.
Yeah, no, thank you for sharing that because it is true. I mean, just the way that the law is written incentivizes. It's like sort of baked into the way that the law is written to incentivize this automation. And you're exactly right about the fees. There's great research on fines and fees done by really wonderful scholars and advocates. But it's also interesting because oftentimes electronic monitoring is touted as being cheaper than incarceration. And my response is always, well, cheaper to who, right? Like if it's family members and people on monitors being charged, it's not cheaper for them, it's just cheaper for the state. So let's be clear about who it's cheaper for. And then the other thing that often happens in, for example, in the South, where agencies can't really afford to contract with these big companies, the companies just contract directly with the person. So the state isn't even part of it, which is really interesting because then it's like the state has and lawmakers have every incentive to do this because it doesn't cost them anything. They just let the private company come in, do their thing with defendants, and they have no part in it. So it doesn't cost them anything, but what they get is, constant surveillance of people on probation, parole, and pretrial release. So it's like a win-win-win for municipalities because it's not their money that they're spending. So I thank you for raising that. Any last thoughts? Thank you so much for sticking around. I know a lot of people at class. I really appreciate your thoughts and comments. And if you have other thoughts, please come chat with me afterwards. I'd love to hear. Thanks so much. Great. Thanks for having me.